technologies, visit fda.gov.
Ask an attorney about Florida law. Ask an attorney, just give him a call.
This is Ask an Attorney, all about Florida law with attorney Joe Pippen. If you have a legal question, call Joe right now. In Tampa, call 813-287-5700. Anywhere else, toll free at 877-943-9673. That's 877-943-9673. The law office is open. And now your host, Joe Pippen.
Hey, good morning. Welcome to Ask an Attorney, all about Florida law. I'm attorney Joe Pippen, practicing attorney, and in studio with me today is attorney Patrick Smith. Good morning, Patrick.
Good morning, Joe.
Patrick and I are going to try to help you in any way we possibly can today by answering your questions. It can be just a problem question or a legal question. We talk a lot about wills, trust, probate, guardianship, power of attorneys, healthcare surrogates. You can also ask about family law, Medicaid law, personal injury. Whatever your question might be, we're more than glad to try to help you. We have a toll-free number, 877. You're listening to a live show on October 26, 2019. And Patrick and I are up early this morning just to help you understand legal issues and understand legal problems and answers to legal problems. 877 is your toll-free number. Toll-free, 877-943-9673. 877-943-9673, and phone lines are open. So, Patrick, can a trust be... Patrick and I talk a little bit about interesting things that might have happened to us during the past week with our practice while we're waiting for you to call with your legal questions. We would much prefer to answer your legal question than talk about cases this week, but some of those cases are fun to talk about and interesting, and we'd like to share some of that with you. Again, 877-943-9673. So, Patrick, what if you had a case where your client died and the trust, say, let's provides a third to a spouse, a third to a child that has an addiction that has those special clauses in there about they can only get so much per month and subject to random and mandatory testing, and suppose the other client or the other beneficiary is like a 10-year stretch. Mm-hmm. So the spouse and the addicted child agree that the third child, they wouldn't have a problem and would agree to that child getting their share outright instead of a 10-year stretch. So how do you go about modifying a trust or terminating a portion of a trust or making a change to a trust after the beneficiary, after the creator of the trust has passed away?
Well, there's a handful of ways, and I think that, first of all, you always look to the terms of the trust. You start there. The trust will always lay out ways that the trust may or may not be modified. In a situation like you're describing, usually the trust will say it's irrevocable upon the grantor's death, so now you're left with judicial modification, post-mortem, and you're going to have two different paths to success there. It's going to depend on which rule against perpetuities was used, whether they use the common law rule against perpetuities, which we standardly do, or if they went with the statutory rule, which is 360 years. So assuming that they went with the common law rule, what it's going to be is a petition for judicial modification post-mortem to effectuate the grantor's intent. You're going to have to serve all interested parties, and that's a bear trap a lot of people step in. They serve the current beneficiaries, but interested parties is more broadly defined. So, for instance, in your hypothetical, the one who's getting the stretch over 10 years, what if he dies year 2? And if it goes to, say, his children or some other beneficiary, now you have to notice that beneficiary, because by taking out that 10-year stretch, you've materially affected their chance to inherit, and they have to be put on notice of that fact. So I think that you have to look at the terms of the trust, and then beyond that, I think you go to the statute, you petition the party, all the interested parties, and I think that you stand back and wait for the objections to pour in.
So if the beneficiary were the other two beneficiaries and the person had no children, that would make the case a lot easier.
Yeah, I think if you have a situation where all interested parties have given written consent, I think there's a much better chance of success. But remember, you're up against the wall, because the poll star for any judge in this case is, what did the decedent want? Yeah. Why are you changing it?
Yeah, the four corners of the document argument, basically.
Yep.
So what, aren't there some timelines, though, on that you can do some of these cases after a certain timeline? I forget when the statute changed to where you might not have to go through the court, that just the beneficiaries could agree.
I think it was 2000. I think 2000 was the critical year, and it's trust drawn after 2000. I'd have to check the statute. We don't do a lot of post-mortem judicial modification, but you do see it every so often.
Yeah, so in this particular case, the trust was, let's say the trust was drawn in 1992, but they did an amendment in 2017. So is it when the trust was drawn or when the amendment was? That's a good question.
Yeah, but I think it depends on what the amendment addressed. If the amendment addressed the distribution, then I think you're under the post-2000 rules. If the amendment addressed just trustee or some statutory update, then I think you're under the old rules. I think it's grandfathered in.
All right, so if you'd like to call the show, you're listening to a live show. Attorney Patrick Smith. I'm Attorney Joe Pippen. We're here to answer your questions. 877-943-9673. Let's go to Mike and Dennis.
Hey, Joe, how we doing?
Doing great, and you?
Good, sir. Good. I was sort of compelled to call you because my aunt, who had passed away, had a trust, and she left the funds. In the trust left monies for her grandson, who is the the trustee, I would think. Then handles the distribution, and then her stepson, and then my mother. And my mother's sister, her two sisters, which are my mother's 92 and my other aunt is, say, 89, just to give you an idea. They're up in age. But what we've come to learn is that he had an initial attorney here in Florida. He's out of Michigan, but because the trust is in Florida, he hired an attorney in Florida here. And it came down to the point, I think, there was $200,000 that my aunt had in investments, and then another $300,000 she had in her estate. So when the first attorney he went to, I think her grandson is being a little slippery about this, because what he's done is the first attorney actually fired him as a client, because I don't think he was holding up to his fiduciary duties to execute, the trust as it was written, because the first go-around that we received did not include the mortgage on the house that my aunt had left him. The second time we received documents.
Well, what do you mean didn't include? Mike, this sounds like too much of an involved question doing a short 1 or 2 minute question and answer on a radio show.
Gotcha.
If you could summarize your question into a sentence or two, that would be great. But basically, a mortgage, if a house is left, if a house is in a trust and left to someone, it can be distributed to the person, but it'll still be subject to the mortgage unless the trust says to pay the mortgage off. That doesn't happen. Is that the question?
Well, I just wonder how we can hold him accountable. Because it sounds like say the first attorney went to hired him as a client because he was asking him to do things that didn't include all the funds, or that would actually favor him more than and not evenly distribute the funds. I was just curious.
Hold on, Mike. Are you saying a client asked a lawyer to do something that wasn't ethical?
Exactly.
Never mind.
Well, Mike, let me say this. Every beneficiary is entitled to a full accounting of what's in the trust and what assets, what bills have been paid, and what their distribution is going to be. If any beneficiary questions whether this is valid accounting, they should have their own attorney to challenge that, and that can be done by going through the other attorney or even maybe going to court. So every beneficiary has a right to a true and proper accounting and a proper distribution of the estate. And if you've done everything you can do yourself, then it's time, and with no good result, then it's time to get an attorney to help you. And Patrick, why don't you add anything you like to that, and then we'll let hopefully Mike get some help there.
Yeah, Mike, create a paper trail. So all your correspondence with whomever, if you're speaking to the trustee or the trustee's attorney, just create a paper trail. And that way, because memories get fuzzy and people's recollections change, you deal with revisionist history, especially if you are dealing with someone who's truly nefarious, which it sounds like you may be. If they're asking an attorney to create or be creative in the accounting process, I mean, that's such a breach of fiduciary duty, and one of the key fiduciary duties, the mandatory duty to account. So I think that the more you put in writing and reduce your communications to writing, the better off everybody's going to be there.
Gotcha. Oh, that's great advice. And can we actually then, would that attorney that fired his client, the grandson, be able to? Would he be the way? Well, you think he might be the one that, since he has fired?
Who's the trustee? The grandson?
Yes.
So the attorney basically said he didn't want to do. He didn't want to help. He didn't want to be the grandson's attorney for the trust administration.
Exactly.
And so then the grandson went to hire another attorney.
Yeah, another attorney at Punta Gorda, Florida, and either he BS'd him through the process and just got them to, or either they're knowingly, or which I doubt they're knowingly doing it. It's not worth it, I would think.
The bottom line is every beneficiary has a right to a proper accounting, and trustees can be removed. The judge, the court can compel proper accountings. The court can do lots of freeze accounts, can do a lot of things until this gets earned out. So.
Yeah, that's the right answer. It's a matter of you just got to go back and sort of hold them accountable for any material breach of fiduciary duty. And we're dealing with the case right now where this case has gone on for years and the beneficiary was sitting back getting money. So the beneficiary is like, oh, this is normal, right? And turns out for the last decade plus, the beneficiary's never received an accounting. Like, they've been getting checks, but they have no idea if that check is accurate. But
they probably never asked for one even, but they should have gotten one.
But they should, unless they specifically waive, they get it. So that's the rule. And at the end of the day, it's one of those things, you don't know what you don't know. So you just sort of need to go back, Mike, and sort of reconnoiter kind of the lay of the land out there. And do you currently have counsel representing you?
No.
Okay. Then, yeah, you just give Joe a call because you're in the Venice area, it says. So, and
right.
He can give you a consultation, because you need a little more in private setting for this sort of legally intimate kind of topic, and he can sort of walk you through what your options will be.
Okay, great.
All right.
All right, guys.
Thanks for listening.
Have a great
All right.
day.
Thank
you too, Mike.
All right, you're listening to Ask an Attorney, all about Florida law. I'm attorney Joe Pippen, and attorney Patrick Smith's in studio today helping me answer your legal questions. If you have one, we'd love to help you. You have a toll-free number at 877-943-9673. Phone lines are open. Let's go to John in Crystal River. Hey, John.
Yes, good morning.
Hey, John, what station are you listening to there in Crystal River?
96.7.
All righty. I'm glad you called. We don't get that many calls from that's a hard rock station that carries Ask an Attorney. Right? But I'm so glad you called.
Yeah,
what can we do for you?
Yes, sir. Oh, actually, I was listening to 107.5.
Okay.
Yeah, my wife went through hip surgery here like a year and a half ago. And she broke her hip and pelvis. And she's got pins and screws in her hip.
Mm-hmm.
And she's got blood clots in her left leg. And I've tried to get her help. I took her to the local hospital there in town, and they kept her 3 or 4 days and kicked her out. And she's been bedbound for like a year and a half now. She can't go to the bathroom. She has to use a bedpan.
How did she break? How did she break her hip?
She fell in the house.
Okay.
You got to come up with a better story than that, John. That's not very exciting.
Well, the reason I asked the question, if she had, fallen in a grocery store or in a commercial property or something, and there was something that made her fall, that would, that would be a legal question. But,
skateboarding or something.
All right. So, but you, okay. So your question is, you can't get proper medical help for her, or
right? She needs therapy, and we don't have insurance, and she's dying.
Oh, I'm sorry. How old is she?
She's 61.
I
can't get her no help. I don't know what to do.
Have you tried to, maybe you should visit with a Social Security disability attorney in your area there that can guide her to proper government assistance that might be available besides Social Security disability payments or possibly Medicare or Medicaid. I think my answer would be for you to find a Social Security disability attorney / Medicaid attorney in your area that can maybe see what benefits and what local agencies might be of help to you.
Okay.
Hey, John, how many years you guys been married, if you don't mind my asking?
I'm going on 30.
Wow. Congratulations on 30 years. And, John, we'll keep you in our thoughts and prayers, but Joe's advice is spot on. I mean, that's exactly... Because and I don't know, this is just me pleading my own ignorance. Medicare is not an option at 61, correct?
She might be entitled to Medicaid, though.
Okay. All right.
Some Medicaid issues there. Is she,
Yeah, I'm just trying to...
If she's at home, she's not in a nursing home or anything like that at this point?
No, we can't. I mean, the hospital won't even keep her. They keep her 3 or 4 days and boot her out. So that's all they can do.
Well, she might be. Would you be opposed to moving her to a nursing home?
Well, if it'd be short term, yeah, something like that would work. But she needs therapy.
Well, they do therapy in nursing homes commonly, so occupational and physical therapy.
Yeah, talk to a Social Security disability / Medicaid attorney in your area. If you can't find one, you can call me and I'll be glad to give you some resources that might be able to help you find an attorney in that area.
Okay, I sure appreciate it.
And we have a toll-free number, 1-800-226-3529.
Hold on a second, sir.
I'm going to give it out several times during the show if you want to keep listening there.
Yeah, I'm going to keep listening.
All right. All right, John, I wish you well, man.
Thank you very much.
God bless you, John.
All right, let's go to Steve in Bradenton.
Hi, my name's Steve. I have a divorce question. My daughter is married 23 years. And
Did she live in Florida?
yes,
Okay.
Bradenton. And the husband just told her he wants a divorce. And they have a property that, while they were married, that he paid 100% for.
He paid 100% for?
Yeah.
Okay.
It came from an inheritance from his parents when they passed away. And he needs some legal rights of ownership of the house. She's on the house name.
Oh, he put her name on the house.
Right.
Okay.
And
well, generally, there's if a marriage is less than 7 years, there's one set of things that could happen. If it's between 7 and 17, there's another thing. And if it's over 17, generally everything that's held jointly would be split 50-50.
Okay.
And it doesn't matter. Now, generally, if he had an inheritance that he'd kept separate, that wouldn't be a marital asset. But since he received an inheritance and put her name on there, that would be a marital asset. So I'm thinking, and usually I tell clients you can't cherry pick one asset in a divorce question and expect me to tell you what's going to happen to that one asset when there are many other assets and many other factors involved. But generally, sir?
No other assets.
No other assets.
My other question is if she moves out with her son, it's their son, I should say, does that affect the ownership?
No, I think if she abandons the property, that's not going to affect her ownership rights of the property. Now, some states have abandoning rules. I was asked a question about a case in Colorado, which I didn't know anything about, but the client was told that if they abandon the property, then they're going to lose their right to stay there or to have it divided. But I don't think Florida has a rule like that at all. So it's going to be a 50-50 split. And she, as a spouse, if he's been the primary provider of income and everything, she might be able to have a divorce attorney give her the right to stay there for a period of time.
She's unemployed right now, and he's a low income, and she was the main support when it comes financially. But right now she's unemployed.
Steve, I would have her, under those circumstances, I would have her contact the Hillsborough Bar Association. They have some pro bono plans that can help a person in that situation.
Really good. I appreciate your help.
All right, thank you. All right, you're listening to Ask an Attorney all about Florida law. Attorney Patrick Smith is in studio. I'm Attorney Joe Pippen. We're just here to help folks today. And if we can help you in any way, give us a call. Phone line's open right now, 877-943-9673. 877-943-9673.
Joe, you mentioned that we talk about cases, and I have a case to talk about between callers. But
Okay, go ahead.
The way you teased it was like, boy, wouldn't they like to know what we talk about before the show? You know,
Yeah.
those are the really good stories. So what we should do is one day we should do like a special segment, like before the show, like the pre-show, and they could hear those conversations, because those conversations are quite interesting sometimes.
Maybe we could do that on YouTube. You know, we could just film it ourselves and put it on
Well,
YouTube.
with our new travel plan, what we'll do is we'll put the phone up, we'll go live in the car, and then
There you
we'll
go.
just go from there. No, the colleague that we were talking about, our friend, who's close to your age, had a case involving a fiduciary situation, like Mike from Venice's question. This was a guy who was trustee of a trust, and the trust said equal shares to the 4 beneficiaries, and there were 4 properties. So he deed property 1, property 2, property 3, property 4, each one to a different beneficiary, because there were 4 properties. Everybody got a property. Everybody's happy, right?
What about the value of the properties?
Don't pay any attention to the value per the trustee, because everybody got a property. Well, one of them, there were 3 vacant lots. And you can guess who got the 3 vacant lots. The trustee was also a beneficiary, and there was one large commercial property. Guess which one he got? And that's how that lawsuit started. But the point was, in this particular trustee's mind, he honestly thought he had done nothing wrong. He thought because it said equal shares and there were 4 properties and everybody got a property, that was equal. It didn't matter the value. And that's the one thing I remember when he was telling us about this case. It was a situation of the genuine honesty in his eyes. He honestly thought he had done nothing wrong.
Yep.
And it's just baffling sometimes.
That's why Mike, should have an attorney, and you're entitled to a full accounting.
Amen.
Every beneficiary is entitled to a full accounting. Now let me give out the phone numbers. You have a toll-free number, 877-943-9673. 877-943-9673. We're in the middle of trying to close, and phone lines are open. Please give us a call if you have a legal question. We'd love to help you. We're about halfway through the show now.
Wow.
And we would like to help you. So I have a case where we're ready to close a trust. Lady, she had no children, but she left everything mainly to charities. She left a sister, I think, $50,000. And the trust, I had amended a trust that was done by another attorney, years ago. And in the first trust, the lady got $50,000. In my amendment, the beneficiaries were revamped, but she still got $50,000. So now my client died. We're close to closing out the trust. And the sister who got the $50,000 is upset that she didn't get all the money, and she refuses to cash the check. So now I've got to figure out how we're going to I'm going to write she has an attorney too. I'm going to write a letter to the attorney and tell him I'm just going to put her $50,000 in the court escrow system and let her do her own petition to get it out and go ahead and close the estate.
Yeah, I think if you noticed everyone under the rules, they have the 6 months to file the objection. If they don't file the objection, they're dead in the water.
Yeah.
Otherwise, it's the 4-year rule, which is, that can be a nightmare, obviously.
Yep. Let's go to Phil in, where's Phil calling from? Hernando County. Hey, Phil.
Hello.
Hey, Phil.
Hello?
Yes, sir. What can we do for you? And what station are you listening to?
570 a.m.
570, okay.
in Brooksville.
All right, very good. What can we do for you, sir?
Had a mortgage company trying to mess around with a foreclosure when they really didn't, because I was listed on the warranty deed here with rights to joint rights to survivorship for the property and the dwelling.
Did the other party die?
Yes, my father passed away and left me and my mother with rights to survivorship. And I spoke to an attorney a few years ago. He said, just keep making payments, nothing's in probate. Well, this other loan moved from 3 different companies. I had to hire a law firm, and they said it was a $50 consultation fee, and I met with the attorney, and he says they don't have nothing. We'll write a letter. And they charged me $25. And I'm thinking, well, that doesn't sound right, but here you go. Here's a check for $75 total. And then about 3 months, 4 months later, I got a bill for $166, and $1.20 of it was
from the law firm.
From the law firm for retainer fee. And
But did you sign a retainer agreement?
I don't. In any of the application when I first filled out there, I could not find anything on that.
Well, hey, why don't you send a letter back to the attorney asking for a copy of the retainer agreement before you pay the bill?
Well, I already paid the bill out of good faith because I don't think, a letter was $25 to write it. But I questioned it as to why they billed me 4 months later.
Mm-hmm.
And their customer service attorney said, okay, we'll look into it. Well, then I got a letter from the attorney saying you owe this law firm nothing, but we will no longer represent you. But I still went ahead and paid it because out of good faith.
Okay.
So then yesterday, in the mail, I got a bill for a phone call that they made to me just to follow up in August if everything was okay for $12.50. So I spoke to the same gentleman, and I said, why are you guys billing me late? I don't understand this. Why can't you just tell me these prices up front?
So, it sounds like you're dealing with a paralegal firm or something. It doesn't sound like you're dealing with an attorney. Those prices are not reasonable for what a licensed attorney would be charging you to write letters or do things. But I'd be interested to see a copy of the stationery on which the bill was received.
Yeah, don't say the attorney's name or anything, but it would be, if you don't...
They're a reputable law firm that was referred to me near the courthouse in Hernando County. They have many departments. He was an attorney, the first gentleman I met with. I just didn't understand why they just had a delay with it, why they didn't say up front, hey, it's going to be $300.
Why don't you write him a letter? Why don't you write him a letter and ask him that, and outline your circumstances and have it on file, and tell him you just don't think this is right, the way they do business and handle themselves, and give them an outline of your story that you just told us on the phone, and put it down in writing. Tell them, I don't understand why you do business this way. And you've talked to an attorney, which you have, and the attorney questioned. Also, it didn't sound like a reasonable way to approach things. But I would first ask for a copy of the retainer agreement.
Okay.
Because if they can't provide that, then I don't think you have any probably liability to pay any bills, other bills.
Well, I did pay it out of good faith. Right. I mean, it was $165. What upset me is that they gave me an interest late payment of $1.20 when I just got a bill for the first time.
That doesn't sound like good business, does it?
That was pretty low class.
Yep. All right, Phil. We'll hope you have a good day.
Appreciate it.
All right, thanks.
Thank you.
You're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, Attorney Patrick Smith in studio. We're here to help you for the next 22 minutes. Is all you got. You got a toll-free number, though. 877-943-9673. 877-943-9673. Had a client recently came in. Do we have my producer wants to say something? Yeah, go ahead.
Yes, I have a question for you. I had a caller called in and didn't want to get on the air. So the question she has is, there is a condo for sale, and it has a no pet policy. And unfortunately, she has a cat that has a paper from her psychiatrist that says the cat helps her with depression. Does she has a case to fight with that, or does she not?
Yeah, I think under federal law, you can have, if you have a letter from a doctor that your pet, what do they call that? A companion pet?
Service animal.
Service animal, yes. Yeah, even though they have no pet policies, most places have to honor a service animal, right?
That's right. I mean, I don't know of a case that lines up perfectly with that one, but
yeah. So I think for the caller, who will be glad to talk to you on the air and ask you a few questions, perhaps. But if the caller has a doctor's letter saying that she needs a service animal, I believe she'll be able to keep her service animal. And I think even though if there's a no pet policy, that doesn't pertain to a requirement that they honor a service animal.
Yeah, I just think I wonder. There's got to be guidelines, though. I mean, a cat or a dog, fine. But if someone, they're getting on, flight 722 to Miami, and they've got their service crocodile with them, I mean, you're not going to let them on the flight. So
no, they are restricted. I know you can have a horse, a miniature horse, as a service animal. That's a legal thing. And our attorney in our firm, Catherine, our family law attorney, knows all about that, because on her radio show she used to had a little article about service animals and how to find out more information. And I used to listen to her on the way in, and she used to talk about the small horses as can be a service animal. So, all right, let's go to Dan in Jacksonville.
This morning.
Hey, Dan, how are you?
All righty. Quick question. On a real estate closing, the person that was buying the property backed out at closing and then refused to sign the release to release their down payment. And so it went to escrow. The escrow agent has it in escrow. How do we go about getting it out? Or what length of time, or what do you have to do in order to get it out?
Did the escrow agent put it in the court registry?
As far as I know.
Yeah,
they did.
That's what they would do.
Yeah, then, Patrick, you have to petition the court to get it out. Yeah, you
just got to petition to get it removed per the terms of the contract. In essence, what you're seeking is some sort of specific performance under the contract, not the actual sale of the property, but the return of the money. So you just actually bring that petition, reference the contract, serve it on the interested parties. It shouldn't be a problem.
So, with the local courthouse is where you got to file for it?
Yeah, it would be the county courthouse in the venue of that dispute. Yes.
Yeah, just confirm it was the escrow agent did put it in the court registry.
And that's a fair point. You got to check the contract. The venue could be any county, but usually in those deals, it's the county where the real property is located.
Okay.
Now, usually when somebody backs out of a contract, the deposit, I would say, is at risk. But the four corners of the real estate contract are going to say, what? Did they have a valid reason? And what is the contract?
It was the buyer and his sister had gone in on it, and then at the last minute, the sister, which had the down payment, decided to take the money and run. So because of that, the person that was the primary couldn't qualify for the loan. The loan collapsed because of it.
Yeah, I mean, under most standard contracts, the deposit's not going to be refunded at that point because you're beyond most real estate contracts. It's like, what, a 10-day window from the effective date of the contract for the deposit.
Yeah, and did both of those people sign the contract?
Yes, they did. I mean, we were literally at closing.
Yeah, and there was a letter somewhere along the way that they had qualified for a mortgage?
Correct.
And then one of them back out?
Correct.
I'm thinking that's not going to be returned.
Yeah.
I mean, I don't... From everything that Patrick and I can listen to and put a quick thought on it, we don't think that's going to be returned. But there could be something else in the contract.
Yeah, get the contract reviewed is the short version.
Okay, well, that's what we got to do. I got to go back and look at the contract more closely. But I was told by the title agent and the real estate agent that we were doing, and that
that's okay.
By them not
real estate agents give bad legal advice all the time. That's not new. So.
All right, Dan.
Okay, thank you.
And call from Jacksonville. We do have offices in Jacksonville. I'll be there this end of this week. And Patrick, tell us where your primary offices are.
So we've got offices in Claremont, Leesburg, the Villages, Apopka. We also meet with clients in Lakeland, Davenport, and Largo.
All righty. And let's go to Paul in Winter Haven.
Hey.
Hey, Paul.
Hey.
Paul, are you there?
Yes, sir.
What station are you listening to this morning?
WLBF.
All right, 90.3 FM. All right, very good. What can we do for you?
A 98-year-old fella passed away, no family, and he left a will, bequeathing everything to me.
Do you have the original will?
Yes.
Okay.
And what is the process of getting that done? Do I just take the will to the courthouse with the deeds and paperwork, or what do I need to do?
You need to hire an attorney.
Okay.
To properly probate the will. So basically what would happen, let's say you brought the will into our office. We would file it with the court. We would get a list of the assets. We would petition the court to have you appointed the personal representative. Then you'd have the legal authority to deal with the estate and distribute it to yourself. And there's some court requirements along the way that we supervise you through all of that and do most of it for you. And then at the end of the day, we close the estate, and you would have all those things in your possession.
Okay.
Now,
all righty. I appreciate it.
Hey, Paul, how's my hometown of Winter Haven doing this morning, by the way?
It is beautiful, sunny.
Oh, good. You take care of Imperial Polk County for me while I'm not there. To follow up, I'm sorry about your friend, first of all. When did your friend pass away?
September 26th.
All right, so you missed a deadline there. There's a 10-day deadline to get the will put on deposit with the courthouse. Don't panic or anything, but just know that there are some things that are time sensitive, so you want to get that appointment scheduled sooner as opposed to later, okay, Paul?
I appreciate it.
All right. Good luck to you.
Have a blessed day.
Yes, sir, you too.
All right. Let's go to Ann in Ruskin. Hey, Ann.
Hello.
I'm
here.
Wait, are you listening? What station are you listening to? Are you listening to 96.3 FM or? No?
I have no clue. Probably.
No clue. All right. Well, there's multiple. You could be listening to 570, 860, or the local Sun City Center station 96.3. So we're on like 14.
It's Sun City Center.
Oh, okay. That's 96.3 FM. Okay. What can we do for you?
Okay. I started receiving Social Security in August of last year. And I received a severance when I lost my job in February. And Social Security has come back and said I owed them $22,000. I've tried to hire an attorney since I've done everything I can through Social Security to see if I can get this resolved. And I've been told by several attorneys that no one will take the case because I've already started receiving Social Security. So, what I don't...
have you talked to a Social Security attorney? Because I have an office there in Sun City. I could refer you to one to talk to.
That would be awesome. I have talked to several, and they basically say once I start receiving Social Security, that no attorney will take me as a client. Were they able to look at things for you and tell you that the Social Security is correct, that you owe them the money? Nope.
Nobody would even look at that for you?
They will not even talk to me. So I would love a referral. What ended up happening is I have been down to Social Security and worked with them about a dozen times. I filed 2 requests for reconsideration to be able to be there in person, and they've denied both of those. They have not allowed me to even come in and be in the hearing at all. So I have lots of questions about how they even came up with that dollar amount.
Okay. All right. Well, you can contact me. I'll give out the numbers here in a few minutes, and contact me off the air, and I'll give you some phone numbers.
That would be awesome. I would appreciate it. Thank you
for
your help.
Thank you. Phone lines are open. You can call in at 877-943-9673. Phone lines are open. Let's go to Nancy in St. Petersburg.
Hey, Joe.
Hey.
It's Nancy.
What can we do for you this morning?
This is a follow-up to the question about the service animal. I called about the service animal.
All right, great.
And
so you have a doctor's letter?
A few questions. Yes, I do, from a psychiatrist.
All right, and have you showed that to your landlord? Or the condo? Do you own a property or do you rent? Do you own a condo or do you rent a condo?
No, I'm looking to possibly purchase the condo, but it's in the condo facility is a no pet policy. And I don't want to pursue buying the condo and then be told, no, you can't have your cat. You said that you had the name of an attorney, a family attorney, Catherine someone.
Yeah, Catherine Holt.
I didn't get that down.
No, but let me ask you this. So you met with the condo people. You have a pending contract?
No, I do not. I do not. This is just it's in anticipation of purchasing a condo in that facility. I'd like to buy a condo in that facility, but I don't want to purchase it and then be told I can't live there. So I just want to make sure that, yes, I can.
Well, no, ask the realtor. Okay, ask the realtor to find out for you the condo association president.
Okay.
And can you think of anyone else that should be asked the question, Patrick? But the condo association the realtor should be able to contact the condo association and verify for you that they will honor a service animal.
Yeah, I don't think there would be any city or county zoning that would need to be notified or anything. It would just be the local association.
But my family law attorney, her name is Catherine. Catherine Holt. You could call our office if you want to talk to her a little bit. She's very experienced and knowledgeable about service animals. And her phone number is 727 586 3306.
3306.
Yeah, and go to extension 200 and ask for Catherine.
Extension 200. Okay.
Hey, Nancy, I think maybe what you need a little bit here is some what we call legal posturing. I recently discovered that apparently small horses are available as service animals. So why don't you go in with, listen, my small horse and I are going to be moving in, and then hit them, with the cat, and they're like, okay, well, at least she's off the horse now. Like that's so just create their paradigm for them, help them accept your reality.
Hey, that's a great idea.
Tell them you have now we're not coaching you to lie, though. I must say that this is kind of in humor, but I was thinking the person could tell them you have a small service miniature horse and a cat, and you'd be willing to give up the horse if they let you keep the cat in there without any conflict.
Yeah, that's some creative psychology there.
All right. Well, that's what we're here for. All right. All right, Nancy, thanks.
Thank you. God bless.
Right. God bless
you, Nancy.
All right, so you are listening to Ask an Attorney all about Florida law. You have about 7 minutes left in the show. You have a toll-free number at 877-943-9673. Hey, you could have been, it's a little late to tell you now, you could have been watching all of this on WeBeam TV, but they have a list of our previous shows on their online TV station as well. Patrick and I both have Facebook accounts, and we're streaming live on Facebook right now too. And Patrick, we can send over the whole show to your Facebook page too. I think
that'd be great.
And we have YouTube channels, and Patrick has Instagram rolling. We have lots of online service things that we are post things on, and you're welcome to join us on any of those. And Patrick, why don't you give us your phone number?
Yeah, that's our ever-expanding social media footprint.
Yes,
that's what we
absolutely.
Call
that. So. All
right. My contact information, so you can reach me directly at the office here in Pinellas. It would be 727-586-3306, extension 306. You can email me directly, and that is Patrick Smith at attypip.com. The Lake, Marion, Sumter County offices, 352-241-8760. And on Facebook at Attorney Patrick Smith, and on Instagram at Attorney Patrick Smith.
All right, and if you'd like to contact me, I'm just going to give one simple number, 1-800-226-3529. That rolls, all of our offices are connected to that number as well. If you want to be called in and want to talk to Patrick, we'll transfer the call to him on that number too, 1-800-226-3529. Go to extension 200, and the young lady there that answers your call would be glad to take care of you.
Hey, Joe, and if I can, before we queue up the next caller, I wanted to say a very special happy birthday to my son, who is turning 14 today. We love you, Will. We're very proud of you, buddy, and happy birthday.
Happy birthday, William. William's a special young man, and always like to see him, be around him. He's just a
5'11" now, Joe.
Oh,
5'11".
All right, he's going to be eating soup off of your head pretty soon.
That's what he says.
Hey, let's roll on to Roland in Jacksonville.
All right.
Hey, Roland.
Good morning, gentlemen. How are you?
We're doing great.
Good morning. How are you?
Doing great. What can we do for you?
Hey, my question is, I just retired out of the military.
Well, thank you for your service.
No problem. Decent pension, be 100% VA disability for things that occur in your career. And I'm 60, and I consider myself unemployable. I would not hire me because I have memory issues.
Mm-hmm.
And I was wanting to apply for Social Security disability. And I've clicked on a lot of the sites saying how to apply, and a lot of them ask, do you earn more than $1,000 a month? And the answer would be yes. So I wonder if that's a disqualifier. Are they going to disqualify me for that because of my income?
The best thing I can do for you, Roland, is to get you in touch with a Social Security disability attorney in Jacksonville. So if you want to contact me, I'll certainly help you find one.
Okay. But you recall, I mean, off the
yeah,
top of your head,
I didn't think there was an income cap on Social Security disability.
Okay.
So I'm not sure what you're looking at online, but I can definitely maybe even look that up a little bit, or I can refer you to a Social Security disability attorney in Jacksonville.
Okay, sounds good. Get a number from you?
You have to call me off the air because I don't have the number memorized, but call me off the air and I'll be glad.
Okay, yeah, I've got your number.
All right, thank you.
I'll do. Yes, sir. Thank you.
All right.
Bye.
All right, let's go to John in Bradenton.
Good morning, Joe.
Good morning.
On trusts, is there anything wrong with giving, say, family members that are not beneficiaries of the trust a copy of that trust after I die?
You would give a family member that's not a beneficiary a copy of the trust, and for what purpose would you do that?
Just to let them know that there's no mistake, that they're not included purposefully, and so there's no question in their mind that maybe they got left out by mistake or something.
Well, let me answer this way. If a beneficiary contacted me and wanted a copy of your trust that wasn't included, I would say no, I'm not giving it to you, and you're not a beneficiary. If you want me to write you a letter that says you're not a beneficiary, I'll do that to save you a little pain and aggravation from hiring an attorney. But even if your attorney called and asked me for it, I'm not going to give it to him. So I don't know how you would voluntarily give it to him. They would just be plotting their plan.
Well, that's it. Is this more of a rub their nose in it kind of thing, John, where you just want to make sure that they know you specifically did not include, like you want to deliver that message?
No, I wouldn't say that. I just...
John, see, if I were doing this trust for you, I would put in there, I have omitted so-and-so and so-and-so and so-and-so for personal reasons, period.
Yep, that ends it.
And then I would send, if they put any pressure on me to release a document, I'd send them that one little copy of that one little paragraph, if I had to.
Okay.
I might not even do that.
Okay.
But, all right?
Okay. All right, thank you.
All right. Let's go to Jim in Safety Harbor.
Hey, guys. I'm listening to 106.1 out of Safety Harbor.
All right.
My question is, I'm getting a little up in age, and I own my house, and I put my daughter on a warranty deed.
Mm-hmm.
If I do something stupid like get married for the third time, that house would still go to my daughter, wouldn't it?
Or something stupid like put your daughter on the warranty deed.
I'm glad you said that.
Yeah,
I was thinking
that's okay. I'm happy to jump on that grenade, Joe. So, who told you it was a good idea to put your daughter on the warranty deed?
Well, I wanted to try to get my probate. I'm trying to get everything in order for her when I die.
Well, congratulations.
Hey, Jim, our time is up, unfortunately.
Oh.
Sorry, that was a great question. Basically, you never do that because you give up part of your homestead. You've made a taxable gift, and there's no cost basis.
You know what?
If you hear the music coming up under suite, we're out of here. Though I'm sorry, it's a hard break. So.
Okay, my attorney said I still get the homestead exemption.
Well, it depends on how the deed was done. So if your attorney did the deed, that might be true if you retain the life estate on the whole property. But But there's a gifting issue and there's a cost basis issue, and it's generally not a good idea. But Jim, call us next week.
Okay.
We can talk. All right. Thank you. Thanks for listening to Ask an Attorney. Thank you, Patrick, for coming in.
Thank you, Joe.
Y'all have a great weekend. So long.
Bye-bye.